This House of Lords case from 1868 was part of the development of the tort of trespass, but it took place 65 years before the development of negligence law in Donoghue and Stevenson. So it took place in a time before negligence law even existed. So let me be clear, Rylands and Fletcher is no longer the law in Australia. It's still an important case to understand, and a viewer has requested this case note, but it is no longer Australian law. So what was it all about? Well, Rylands operated a commercial water mill and they were building a reservoir to store additional water. They hired an engineer and a contractor and then they left them to do their work. Rylands took no further direct part in building the reservoir. Now it turned out that underneath the reservoir area there were some old disused mine shafts. The contractor discovered these, but they were full of soil and rubbish, so instead of sealing them off, the contractor ignored them. The reservoir was completed and filled, but due to the shafts not being sealed off, the reservoir burst and flooded Fletcher's newer coal mine, which was still in operation. Fletcher sued. The courts approached the dispute by considering whether the escape of water could be considered a trespass. Now, normally trespass requires intentional conduct, and in this case, pretty clearly, Rylands never intended for their waters to escape into Fletcher's mine. The court found, though, that because Rylands had brought something onto the land, i.e. water, which hadn't been there naturally, then Rylands was responsible for keeping it on his land, and was responsible if it escaped. Lord Cairns, the Lord Chancellor, agreed with Justice Bramwell below, who said, "The person who, for his own purposes, brings on his land and collects and keeps there anything likely to do mischief if it escapes, must keep it in at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape." As a result, Rylands was guilty of a trespass. Nowadays, of course, we would look to negligence, and liability would most likely fall on the contractors who failed in their duty to properly build the reservoir. One more time, this case is important to know, but it is no longer good law in Australia.